welcome on behalf of Arnot Manderson Advocates to the second in the Devil You Know seminar series. As I'm sure you can read, my name is David Turner. I'm a member of Arnot Manderson. In 2020, we're delighted to be welcoming 5 new members of faculty to the stable. Today's speaker, Charles Oliver, called to the bar on the 29th of May, alongside new stable members Kenny Cloggy and Andrew Crosby. Jonathan Murphy and Fergus White will call and join us on the 26th of June. 5 Devils means a fuller Devil You Know programme than previous years. 5 seminars over 5 weeks, which are, I'm told, already fully subscribed. It must be better than Netflix. If you want to join the waiting list, please do contact our clerks, but I'm delighted to confirm that all these seminars will be available on the new Arnot Manderson YouTube channel as soon as humanly possible. Links will be circulated together with Charles's slides. Please feel free to share those with your colleagues, friends, spouses, children. I'm sure there'll be a treat for all ages. As ever with seminars, a few housekeeping matters to cover. You'll all be responsible for checking your own fire exits today. More importantly, there are 2 Zoom buttons which we would like to take notice of. For those who are familiar with Zoom, this may be a no-brainer, but for those that aren't, the first is a chat function. Today, we're going to use that for any technical queries. If you can't hear either myself or Charles, please do let us know. And if there's anything else you wish to raise with the team, please use that function. The second, and arguably more important, is the Q&A button. Given the format of today, questions will be responded to at the end of the talk. If you wish to submit a question at any time, please type it into the Q&A tab and we'll pick it up from there. Turning to our main event, I'm delighted to introduce Charles Oliver, Advocate. I had the pleasure of being Charles's Devil Master this year. Prior to calling to the bar, Charles was a solicitor at Han & Co, spearheading their Edinburgh office. When Charles sent me his CV, I thought I was looking at the profile of a far more qualified solicitor than his tender years. He has managed to cram in a wide breadth of experience, from high-value clinical negligence to commercial dawn raids, with cross-border proceedings and claims, I'm told, over Middle Eastern falcons thrown in for good measure. No doubt that experience will stand him in great stead for his career at the bar, including, I'm sure, the deluge of instructions that will follow this seminar. Although our time together was somewhat curtailed by the coronavirus, Charles worked hard during his deviling period. When he asked if he could take an extended break over Christmas, I had no issue. When he said he was hoping to fly first class to New York, I did wonder if that was the intended purpose of his faculty Lord Hope Scholarship, but I'm assured that he was relying solely on his skills at collecting Avios points. I'm not sure if this kind of fiscal prudence is reflected in Charles's interest in today's topic, but the title suggested it might be. So I'll hand you over to Charles for his talk, COVID, Easing the Lockdown on Expenses Recovery. Charles.
Thanks, David, and thanks everyone for attending. It's great to see so many people having subscribed. I will now try and get the slides up, and if people can't see these, please do make a comment so that we can tell. But no. Yeah. So without further ado, I hope that I don't insult anyone's sensibilities with this slide. But when I was preparing the seminar, I've realised that the ones that I remember best are the ones with some sort of funny memes or images throughout. And honestly, I couldn't actually fit in or find anywhere else to put a meme in or a funny image. So I've done one at the start and left it at that. On a more serious note, however, when I was preparing, it did occur to me that the judicial expenses in many court actions can be comparable to, if not exceed, the value of what the parties are arguing over. Whilst the case law may refer to expenses as an instant of litigation, they can often, ironically, become as important as the principal action itself. Indeed, in the personal injury field, practitioners will almost certainly have had experience of actions which on their face appear low value, simple and straightforward. But as the action progresses, significant procedures incurred and the judicial expenses become a multiple several times over what is the sum in dispute. As far as the present times are concerned, you see there's a link to COVID. So I took the view that COVID presents a double whammy for both lawyers and self-funded clients across a variety of litigation. The recovery of expenses is delayed at a time when many businesses are experiencing a decreased cash flow. As a general rule of thumb, until you get your account of expenses taxed, you cannot recover them, absent an agreement. Taxations, generally speaking, haven't been going ahead. I appreciate from speaking around that there have been some taxations that have proceeded by way of written submissions alone with the consent of both parties. However, that's not particularly helpful where you have a party who might be seeking to avoid paying or delay paying expenses due to their own cash flow issues. One can anticipate with the lockdown that when the courts do reopen, there will be a backlog of taxations in many courts, so that we're not out of the woods yet. All of this would only add to the delay in recovering judicial expenses. The general rule is, as the expenses, you don't get them until they're taxed. In the court of session, you cannot get an extract decree for your expenses until they've been taxed, because the extractor will not know what sum to put on the decree. And indeed, in the sheriff court, you don't get a decree for expenses until they've been taxed, because you have a finding for expenses, then you have the taxation, and then a decree for that amount is thereafter. It is thereafter pronounced. As I say, a delay in recovering expenses when your cash flow has been hit is bad enough. However, there might also be another issue for COVID and recovery of expenses. As I say, many businesses will be experiencing cash flow issues. And that's not just the party who's been awarded expenses, it could be the party who you've got expenses against. And you may well find that a party with a large award of expenses against them will use the delay in getting the account taxed as a form of interest-free loan at your expense. Generally speaking, many parties to a litigation will have been funding the litigation out of their own pocket for several years, and only are able to start the recovery process when they get their award of expenses. And indeed, many solicitors, particularly in the personal injury field, will have been advancing expenses or outlays on behalf of their clients in anticipation of recovering those expenses when lockdown. So when they get their award of expenses, the delay in getting your account taxed then can be a cash flow issues, and that's why I say it's a double whammy. You have a delay in getting your recovering expenses at a time when cash will be tight for many. The solution I would suggest would be, therefore, a motion for interim payment. Now, this is an English case I've looked at, or I've put up here, and it's been referred to in some of the Scottish cases, but it's probably of limited relevance north of the border now. I do just put up the quote of Mr. Justice Jacob, as he then was, just to give us some sort of what I think sort of neatly summarises both the problem and the solution. And he says that the motive for trying to prolong a detailed assessment, namely putting off the evil day when payment has to be made, will be considerably reduced when he who has to pay can only put off the evil day in respect of a considerably reduced sum. Now, before I go any further, again, I hope I don't insult anyone's intelligence, but there does appear to be sometimes confusion when you're talking about expenses, and sometimes parties start referring to the defenders on the assumption, for example, that the defenders will be the party found liable in expenses. I'm going to use neutral terminology throughout this webinar. The paying party will be the party who has been found liable in expenses, and the receiving party, the party, pardon me, who is found entitled to expenses. So if we're looking at interim payments, then if you essentially what I mean by an interim payment is you've had your award of expenses, you haven't got a taxed account yet, but you're asking the court to grant decree ad interim for an amount of expenses on account of the account being taxed, and that's usually done by a motion for interim payment. And there is case law that has been referred to going back to the late 18th, early 19th century, so late 19th, early 20th century. I'm not going to bore you with that. I'm just going to look at a few cases that are perhaps relevant to this. Martin and Co. petitioners was one case where, one of the earlier recent cases, I would say, where Lord Drummond-Young said that such a motion was competent for interim payment of expenses. However, he did say that the party seeking such an award would require to show special reasons. A similar approach was taken in Tods-Murray. Again, I'm not going to go through the history of Tods-Murray. I'm sure there's several people amongst my audience who are quite familiar with what happened in the Tods-Murray against Aragon case. However, I think it was Lord Wilman in that case also considered that special reasons would be required, and indeed it would be an unusual circumstance in which a motion for interim payment would be granted, or for both motions in those cases were successful. One might think, therefore, that a motion for interim payment might be something of a rarity or require exceptional circumstances, but thankfully the case law has changed, or the tide of the case law for interim payment has actually improved as time's gone by. Kidd against Paul was a 2018, Paul and Williamson LLP was a 2018 decision of Lord Tyre. In the commercial court, that was slightly remarkable, and I think the sum of interim expenses sought in that case was about £1 million. And he said, I do not read for my part this observation, and that's the observation in the Martin case, as meaning that an order will only be made in exceptional circumstances. He went on to suggest that what was meant by special reason or special circumstances was that simply there would be sufficient reason for having an award of interim expenses outside of the ordinary way. And from that, as you can see, as time's progressed, we're not, 2013, there's a reliance on special circumstances. It's said to be unusual to get an award for interim expenses, and certainly in 2018, it seems that the tenor of the language is certainly mitigated to some extent. So when you're, it's all very well bandying around phrases such as special circumstance, sufficient reasons. What does that mean in practice? If you're seeking, if you've got your award, if you've got an award of expenses in your favour and you're seeking interim payment, what will sort of be sufficient grounds for you to get a payment on account? These are, I've listed there some sort of maybe examples of what could be could get you or could be sufficient reason for interim payment being granted. If the paying party is on the verge of insolvency, that was the case in Martin and Co. The complexity of the account, or the fact that the receiving party was self-funding, was said to be sufficient reason in Kidd. Delay as well was also said to be a reason in Kidd. And I've suggested there that maybe if you've got a case which is quite complicated and isn't going to proceed on a block fee account, it's going to be a detailed account, those taxations from experience tend to be a lot more protracted. Even after you've had your taxation hearing, you often find it's several months before you get the auditor account back from the auditor. and such. If there's a detailed account prepared, I had one as a solicitor, I think, where there was 200 points of objection, and I think we took 4 months after taxation to get the decision back. Now, in that case, I think it took overall about a year, in actual fact, from a case settling to the payment being received. And that sort of delay, which will often be the case if there's a detailed account in a lengthy case, I would suggest might be something you'd be putting forward as a special circumstance which entitles you to an interim payment. I've also put up COVID. The whole point of this, the whole reasoning behind this talk, or the whole purpose of this talk was, on one view, I was thinking, the delay in getting your account taxed that will come out of COVID will put pressure on many solicitors and many self-funding clients. Is that a special circumstance? Well, I suppose it'll take somebody to make a motion, but I would certainly say it's arguable that the delay of COVID, certainly when you're talking about a 3-month lockdown, which are pretty well, or a quasi, 3 months of pretty much a shutdown of the court service, added on to the usual delays in taxation, that could either be a sufficient reason of itself, or taken with other factors in the case, be a sufficient reason, one would think, for a motion for interim payment being successful. One other element I've put there, because it's something I've done in the case of my own, which is when you get the paying parties note of objections or details of, and I don't mean they're without prejudice negotiations, I mean what they're going to be objecting to. I have sought interim payment of the undisputed element of the account, and that can be quite powerful, because as a paying party, if the receiving party involves a motion for interim payment of sums that you do not dispute are due, it's actually quite difficult, even from a common sense point of view, just to dispute that, because there will be an element of, why would you on what basis would you be disputing sums that actually you're going to have to pay anyway? So sometimes, and in the past that has been something I've relied upon as a solicitor seeking interim payment, is to just rely upon the undisputed elements, which can be the majority of the account. So that can be another factor of trying to get a motion for interim fees granted, or interim payment granted. There is perhaps one divergence in practice I've noticed. That back in 2017, there was reports of some cases in the commercial court where commercial judges were saying, well, look, this is meant to be a simple procedure. I don't want to see a long letter from a law accountant. I don't want to get a draft account of expenses in. In those cases, they were just content with, in many cases for law accountants to give a rough indication in writing of the likely level of expenses to be awarded at taxation. The problem with that approach is there is an unreported decision in McCleary against Jim Clark Memorial Motor Club. In the matter of fairness, there was a case where I acted for the pursuer. This is a decision of Lady Carmichael, where she suggested that where a motion for interim payment is to be involved, there should be some vouching of the basis upon which that sum has been calculated. Now, in that case, it was quite easy, because that was the case where we just relied upon the undisputed element of the account. We had the note of objections from the paying party, and we just simply said, and the additional fee which they would have agreed to, as in they were conceding, and we said, well, look, we're just seeking an interim payment of this undisputed element of the account. Those remarks are strictly obiter, mainly because this wasn't actually the motion for additional fee. This was a matter related to extract, where the extractor had been concerned about whether or not there would be double recovery, for example. But there is a dubiety here, and if you are enrolling a motion for interim fees or interim payment, you do need to consider carefully the extent to which you're going to vouch the sum you're asking for, given that there seems to be a divergence in practice between different senators, at the very least, as to what they consider to be appropriate to come before them to support such motions. And it may be that it's very much case dependent, the degree of vouching that you give forward to support a motion for interim payment. I did say in my talk, in my synopsis when we were advertising the CPD event, that we would look at this from the paying party's perspective as well, and I'm going to make sure on that promise and look at, well, if you're on the other side of this, if you receive a motion or indeed a request for interim payment of expenses, how do you oppose that? Now, as you can see, the first question I would ask is, if you're asking to oppose a motion for interim payment of expenses, think to yourself, do you want to? The reason I say this is, as we'll come on to later, interest will now accrue on unpaid accounts of expenses. And if the sum that's been sought by with interim payment is a sum that you would concede in expense, as you would concede the accountant in any event, then it would often be in your best interests to simply concede to pay over the interim payment if you can afford to, just to save the interest payment. Leaving aside any other tactical considerations, and that comes back to the Cleary, where again we had the undisputed element of the account. You would look, if you just been asked for interim payment of the undisputed elements of your account, then there's a lot to be said for simply agreeing to do that. There will be, as we come on to later, to get an interim payment of expenses, you need to give an undertaking that you'll repay any overpaid sum plus interest, and that will be a question of this. So if the receiving party has got doubtful solvency, that might be a ground for opposing a motion for interim payment if they cannot make good on the undertaking to repay any excess sum. And indeed, I've acted for parties before where that has been the argument I've been faced with, and it can be a challenging argument to overcome. Where there's contra awards, that on one view would be a case where you might want to oppose interim payment, because you may have a contra award where your contra award is going to wipe out the interim payment, or the contra award would reduce the sum payable of the account to a sum which is less than the sum being sought by interim payment. So that would often be a case you might want to look at. Another case is that, what I would say about interim payments, and that's why I put dubiety of split awards, is that if you have an award of expenses, which is quite simple, you've got expenses of the cause and your account's quite simple, it's far easier to seek interim payment. If, on the other hand, you are a paying party and you have, for example, you have split awards where the paying party has been found entitled to the expenses of an amendment procedure, and then there's been a tender, and then there's dubiety as to the date of the tender, and there's disputes maybe as what's encompassed by the scope of the award, or what forms part of the amendment procedure and what's part of the general preparation of the case, for example. In those circumstances, it can be far more difficult to ascertain what will be the likely sum, the net sum which the defender or the receiving party will be found entitled to. And it might be that you as a paying party are saying, well, actually, some of these sums that the receiving party is claiming are actually sums which we say are part of my award of expenses. And that complication of difficulty of working out where one award starts and another award finishes, particularly with, for example, if there's big dubiety over the date of tender, for example, that can be cases that can be a case where you might want to oppose a motion for interim payment. The other thing you might want to look at if you're opposing a motion for interim payment is look at what they're claiming. Does that seem reasonable to you? Take advice from your law accountant. But generally speaking, if none of these circumstances apply and there's no good reason not to pay the award on an interim basis, you may just wish to do so. But of course, you'd want to protect your position by checking that the sum is reasonable and that there's not going to be any solvency risk of in the case of overpayment. And again, that comes down to, as a receiving party, you want to make sure you're not overestimating the sum that you're seeking in interim payment. in the case of interim payment, there's an implied undertaking that you will pay the overpayment back plus interest at the judicial rate at 8%, which is, as I say, probably a punitive, and certainly many parties will be able to obtain funding at a cheaper interest rate than 8%. So you don't necessarily, you don't want to be going out all guns blazing when you're seeking interim payments, and you probably want accuracy as opposed to maximisation is the key here. As I say, Martin and Kidd, it was said it was implied that there was an undertaking to repay the any overpaid sum together with interest, and indeed they were given. Usually, the court will require that undertaking to be given explicitly. McCleary was a case where there was other undertakings that were said to be implied. I personally thought they were more a matter of common sense, and I think so did the judge, Lady Carmichael, potentially, in that you don't want to, there's an implied undertaking that you will not use your interim decree to essentially, you'll not use the interim decree and the final decree for expenses combined to recover more than your total sum due. You have to give credit for any sum that you receive under the interim award. You have to give credit for that when you're enforcing the final decree for expenses, or the principal decree for expenses. And that was a question that had vexed the extractor in that case, because she thought there was a prospect of double recovery. But just, I don't think it would be a matter of arising practice where professional commercial agents are instructed, but just something you need to be aware of. So that's basically how you would get interim. That's basically a rundown of interim expenses or orders for interim payment of expenses. The next issue I want to look at is enforcement, and this might be of more interest to people involved in commercial litigation, particularly pursuers who have brought actions against a commercial counterparty and have obtained an award of expenses at the conclusion of their case, but are restricted in enforcing their decree for expenses because they can't get the account taxed, particularly where there's not a monetary conclusion. For example, you won't have an inhibition on dependent, etc. And as the party bringing the action, you probably haven't been able to get cation against your opponent. So I actually had the benefit of speaking to Director of Operations at one of the big three sheriff officer firms just before this call. SMASO, the Society for Messengers at Arms and Sheriff Officers, are giving guidance on the extent to which enforcement will take place during, or diligence will take place during lockdown. Certainly during the full lockdown period, which we're now out of, it was highly restricted. The current position at the moment is that charges for payments will be, this applies to all decrees, but again, I just look at it from the basis of, you've got your interim decree for expenses. How do you enforce it? Even though this will apply to any enforcement of any decree, at the moment you can serve a charge of payment at commercial property, not residential property. Inhibitions are allowed, arrestments are allowed, attachment earnings are allowed where there's been a previous charge of payment served, and you can't do attachments at the moment. You can just do arrestments. England is slightly ahead of us, so England, they've got basically full enforcement of one second. Somebody's asked me about the higher delta decision, which I'll come back to at the end. If you can give questions at the end, I'll come to them. But the higher delta decision that somebody's asked me about, I will come back to. So HCO enforcement at commercial premises, essentially the full diligence is taking place in England at commercial premises, but not at residential premises or on highways. I will come back to that as to tactics you can use to enforce decrease of interim expenses. Now, there's other issues that arise during lockdown. First of all, we don't have it at the moment, but there is, going through the House of Lords, the Corporate Insolvency and Governance Bill, which will restrict winding up petitions. So if you were hopeful, and in the Martin case, this was due to insolvency risk, so that's what was concerned with. If you have a decree of any kind, whether it be an interim decree for expenses or anything else, you may wish to look at the winding up the commercial corporate debtor. At the moment, there is a bill going through the House of Lords which will seek to restrict that, where essentially where you've got a charge for payment that has been served, you will not be able to bring a winding up petition between the 27th of April and 1 month after the commercial insolvency bill comes into force. Now it's still going through the Lords, so it looks like no winding up petitions will be allowed until probably come into July. Whilst that bill is not in force, the English courts have essentially given effect to it. There wasn't really much discussion of parliamentary privilege, but they looked at the terms of the bill as it's going through Parliament, and an injunction was issued by Mr. Justice Morgan very recently. I've given the citation there, to restrain the presentation of winding up petition. So it seems that that would be one route of enforcement which is out of the window at the moment, and the provisions, when they do come into force, will have retrospective effect. Also, when you're seeking to enforce against individual debtors, I've put the provisions up there regarding the Coronavirus Scotland Act. Individual debtors can seek a moratorium, essentially on diligence for 6 months, and they can do it on multiple occasions. Again, the previous provisions for declaring a moratorium, or you could get a 6-week breathing space essentially, and you could only do it once every 12 months. The position now is essentially you can seek a moratorium for 6 months, and you can do it repeatedly whilst the coronavirus pandemic is ongoing. And during that time, a creditor cannot carry out any form of diligence, pretty much, and they cannot serve a charge of payment, and they're prevented from presenting a sequestration petition. So if you've got, what this really comes down to is, if you've got your decree for interim expenses and you're seeking to enforce it, well, how do you go about it? Well, one thing you can do is you can look at obtaining early extract. I'm not going to go through the rules on early extract. Essentially, you ordinarily get extract in 7 days in the court session. I think it's 21 or 20. I think it's 21 days in Chef Court, or it might be 28. I'll need to check. So once you've got your extract, well, what can you do now? Well, you can serve a charge of payment at commercial properties. You can do an inhibition. You can do an investment. Earnings investment are probably unlikely because you've got to done a prior charge of payment. The other option you can do is you can wait for phase 2. You can attach goods at commercial premises in phase 2. And I think there was certainly stuff coming up from the Scottish Government which says we might be going to phase 2 quite soon, maybe at the next review period. So it might be in a number of weeks that we're at phase 2 in Scotland, whilst they are already in England. However, if you are enforcing in Scotland and it's against individual debtor, just check they don't have a moratorium in place. The other option, which is if you've got a debtor and you've got somebody with who you've got interim decree against, and they have commercial property in England where there's assets, you could simply seek a certificate of money provisions and just simply enforce in England through the High Court Enforcement Officer route. So that is another option, particularly with companies with multiple addresses or assets in multiple locations. But I would say essentially on the issue of enforcement is there's no real easy option. There are debtor protections in place, and that applies to any decree, whether it's for expenses or otherwise. The other sort of interesting element of expenses is the other interesting element for expenses, which might have more impact now in COVID, is interest. Now, when you're waiting a longer time for your expenses to be paid, and essentially there's an added 4 months coming onto the matter of interest, particularly on an account that can be several £100,000 in some personal reactions quite easily. The matter of interest is perhaps of more importance. The common law rule had traditionally been that you would not get interest in your expenses until the auditor reported, unless there was exceptional circumstances. Now, new rules came into force just over a year ago. I've put them up there, and the court now has the discretion to award interest from a period that begins 28 days after the account of expenses is lodged. So if you're in the COVID situation and you've got an award of expenses, how can this help you? Well, essentially, if you're a party receiving, or if you're a party who's a receiving party in expense, and you have an award in your favour, and you think you might not be able to get an award of interim payment of expenses, then the fact that interest will be running at 8% from when you lodge your account might give you sufficient leverage to actually seek an interim payment. And the question that might arise is, do you want to seek interim payment of expenses, or would you prefer to be earning interest at 8%, which is more than you will get, which is more than you're certainly getting any savings account these days, and is more than is probably more than some parties are able to get commercial borrowing at. That is a commercial decision for a firm or their client, but it's something to bear in mind. And I suppose the key to that is to get your account expenses lodged as soon as possible, because until the account's lodged and 20 days have passed, interest cannot run. If you're the paying party, you might even want to volunteer interim payment to account to prevent interest running. And indeed, that was the purpose behind the rule. If you look at the Taylor review, the purpose of Sheriff Principal Taylor bringing in interest on expenses to run after the account expenses is lodged is that he felt that 28 days was sufficient time for parties to work out roughly the amount that is due and to give an interim payment. So that can provide you with some, if you're a paying party, it's something to think about. That, whilst it's all very interesting to look at the case law on interim payment, you might just wish to volunteer paying the interim payment, because otherwise, a year down the line, and in some cases it can be a year from account being lodged to taxation. If COVID goes on for much longer than that, is not that might not be an unusual circumstance. Your liability has already gone up 8%. Just to say something about the procedure for getting interest and expenses in the court of session, it's quite simple. You lodge a motion before you get your extract decree. I put the details of the rule up. As everybody will know, your timing of getting your extract is down to you. It's in your hands of the receiving party. You can get your extract by doing your form 7.1 whenever you want. So you simply enrol your motion before you do that, and it'll come for a Lord Ordinary in the usual fashion. The difficulty might arise, however, in the Sheriff Court. How you obtain interest on the award of expenses is not something I've actually been able to work out too much myself. The rule is quite clear. It's 32.52 that the Sheriff may award discern for payment of interest on the tax expenses. The problem is that the Sheriff is to do so at the same time as he grants decree for expenses. Now, unlike in the Court of Session, the Sheriff will only grant decree for expenses once the account's been taxed and either the period for objections is passed or the objections have been dealt with. And the decree for expenses follows on automatically from the report being lodged. So the report's lodged, I think it's 7 or 14 days for objections. Once that's passed, it'll go before the Sheriff in chambers and he'll grant decree. What the rule says in 32.52 is that the Sheriff may require the party discerned against to pay interest on the tax expenses. There's no indication as to on what basis the Sheriff is to make that decision. There's no indication as to how a party who wants to make representations as to when interest should run from is to make representations, and there is no indication as to how somebody, what step in procedure somebody is to take to get the Sheriff to, or to invite the Sheriff to make an award of interest on the expenses that predates the decree for expenses that will be granted after taxation. There's no provision for a motion in the rules. You might be able to do a motion, but I don't know. And certainly timing-wise, if no objections are lodged, you run the risk that no objections are lodged and the Sheriff 7 days later simply grants decree with no interest or interest from the date of decree on the expenses, and then you could be out essentially a year's worth of interest on what could be a substantial sum of money. I don't know how you resolve this in practice. One case I've seen is for is at the time that the award of expenses is made at the conclusion of the action, is to prorogue the period for enrolling a motion, but that's difficult because of the matter of decree. Once a decree is granted in terms of the rule, it seems that the opportunity to award expenses is lost. It might just simply be a case that you will have to enrol a motion as soon as the account's been taxed. It could be that you simply have to write to Sheriff Clerk or pick up the phone. But as I say, there's nothing in the rules which really gives any indication in the Sheriff Court, as I can see, as to how one seeks expenses on, or seeks interest on the tax award of expenses. So I've mentioned some of this here. As I say, the other thing I'd point out is it's a discretion that the sheriff has to award interest on expenses is not a right of the receiving party. I think, however, the way looking at the tail review, I think it seems that the intention was that the default position, as you were, would be that interest would be awarded on expenses from 28 days after taxation. It's 28 days after the account's been lodged. If you are a paying party, and for example, there's been difficulties encountered by you in assessing the account on the other side, you might wish to say, well, that's a reason why interest shouldn't run. The auditor has sight of the full file. You don't, so it might be quite difficult for you to make an interim payment because you can't assess the account and you've been forced to go to taxation. The only other thing I would say is that I've put up the Supreme Court factors direction. The Supreme Court rule, interestingly enough, is that interest runs from the date the order of expenses was granted, so the date of the finding of expenses, unless the costs officer is persuaded otherwise. That might give some indication that the general rule we're now moving to is that the default position will be that interest will run prior to taxation. I don't know though, mainly because there's very little guidance in the matter. So that's a run through. I think we're in time. That's what's meant to be a quick run through of the expenses procedure we have, or what I think receiving parties can do to try and recover their expenses more expeditiously, and what you can do as a paying party to protect your position. Somebody did mention the decision in Higher Delta. That was a decision of Lord Ballantyne in relation to interim payment of expenses. I didn't mention it for two reasons. The first reason was that decision I don't think has been reported in relation to interim payment, has been reported in relation to the merits. And whilst a certain senior counsel has produced a note on that decision and given a copy of that note, which has been very helpful, I think that you get to the same result you do now by looking at the report decisions. I think, if I remember correctly, Lord Ballantyne in Higher Delta was reported as saying that he did not think special circumstances were required. And I think, if anything, to the person who asked that question, we probably are moving more and more towards that as being the situation. Particularly when you say special circumstances is just going to be defined as sufficient reason. I think that is where we are now. That's, you can move more readily to interim payment without having special circumstances. I think that's probably where we are. And if you remember, for at least 20 years in England, interim payment has been the norm, not the exception. So I think as time progresses, Lord Ballantyne's comments that were reported, but unfortunately not reported informally, but unfortunately not given in a written decision, will probably become the norm.
Thank you, Charles. Now is the time for questions and answers. We have one already, but if I could perhaps jump in before I ask you this question. Well, in fact, the two questions, probably my question and this question, probably link quite well together. Thank you to Bilal Shabir. Do you think the interim payment remedy is underused in Scotland? And if I could perhaps add to that, Charles, in light of the recent decisions and the trend in England and Wales, and particularly in light of Higher Delta, and as you say, the authorities that you looked at today, do you feel that motions for interim expenses are ones that should be being made more commonly than seem to be at present?
Well, so I think before 29th of April 2019, I think the answer to that would be undoubtedly yes. I think it's often said that, particularly in speculative actions, that solicitors and counsel run a business model which is unlike any others, and that one of my devil masters has fees outstanding from has a case that's actually been ongoing for 20 years, and during that time the lawyers are acting speculatively and expected to carry the work in progress on that, and at the end of it, when they're told they're entitled to be paid for it, wait sometimes a year or more to be paid. So I think that undoubtedly you should, before there was ability to receive interest on expenses before taxation, I would see no reason not to make a motion for interim payment if all you have to show sufficient reason. And in large enough, complex enough cases, there should be sufficient reason there. I suppose it becomes now more of a commercial decision as to, do you want your 8% interest, or do you want your payment up? Do you want your money, or would you prefer the cash flow now? And I suppose that will become, particularly in personal injury litigation, where the solvency risk of the insurance company really isn't at stake. And that's why I say earlier on that if you are a paying party and somebody's moving for interim expenses, why don't you just sometimes may as well just be paying it as long as you accept it's money you're going to have to pay. Going back to Bilal's question about is it underused? I think so, yes. The senior counsel involved in Higher Delta did do a note back in 2017 on the case, and that's how I know about it. And it's been going on for 20 years. And there is no reason, I don't think, why you cannot have there's no reason why interim payment or motions for interim payment cannot be more common in Scotland. The only slight difference maybe is in England, there's a tendency to file a schedule of costs prior to filing a full detailed bill of costs, and usually the schedule of costs will be available at the hearing on the merits or at the hearing where costs are decided. So I suppose it's easier for a judge to look at a schedule of costs which he's provided for and as part of the usual English procedure to make a rough and ready estimate of how much he wishes to award, where we don't have that in Scotland. We just have the one account expenses. But as I say, there's no reason why a law accountant can't give a reasonable estimate. And if a judge knows a case has been going on and has been at proof for 8 days, and he roughly knows how much process has been involved, my view is that reasonable estimates can be made as to how much should be awarded for interim payment.
I mean, I think for my tuppence worth, I think I would agree with that. I mean, going back to the principle which is discussed in some of the English decisions, I mean, at the end of the day, the court is awarding a sum of money which it accepts as due and payable, and all that is really being waited for is an account of expenses, and it seems slightly unjust that procedural step, as it were, cannot be circumvented to the degree that the court is prepared to in exercising its discretion, to allow some of that money. And as you observed, Charles, this in any proof there is a degree, I would suggest, of any account of expenses which judicial knowledge will appreciate is always going to be due. For example, it would be very rare for counsel's fees to be refused in a proof, for example, and similarly a degree of preparation. And certainly if a law accountant can give a fair estimate, it would be very unusual for a reasonable proportion, whether that be half or more of that account not ultimately to be awarded. And particularly when any interim award is being made at the risk of the receiving party. On one view, it seems almost unjust for the court not to be considering these motions more readily, and perhaps it is something that the profession has not considered. And maybe your talk and maybe the circumstances at the moment will focus parties' mind, and maybe we might get a reported decision that we can perhaps rely on rather than perhaps some of the rumours and informal reports that we're having at the moment. I will just have a quick double check of the Q&A and just, we have another question from Stefano Rinaldi. do you think there are any situations where interim awards of expenses could be sought before an award of expenses is granted by the court?
Interestingly enough, I mentioned that I wasn't going to speak about the late 19th century cases and early 20th century cases, but I think that is what they were concerned about, where it was a case where essentially under the old rules, the husband will always be, in a divorce case, a husband would always be liable for the wife's expenses in bringing divorce proceedings, regardless of whether or not they were successful. And I think that's what was happening there, is that the wife was seeking interim payment of expenses that she was going to incur in proceeding with divorce proceedings, because she would be entitled to them at the end. Other than that, however, I'm not too sure if there could ever be circumstances where, for previous procedure, you should be awarding interim payment for expenses before you've awarded the expenses, because if you are given interim payment, an award of interim payment for expenses, it should be on the basis that the pursuer will be, or the paying party will be liable for those expenses. And why don't you just make an award of expenses at that point and then make an interim award? If what you're looking at is future expenses, then there can be certain circumstances, particularly in commercial litigation or friendly litigation or other unusual litigations, where it's going to be conceded that the one party will be entitled to be indemnified by the other party for their expenses. Now, the example, I think, there was a case a few years ago where there was directors' disqualification proceedings, and the disqualified director brought a summary application for leave to act as a director of various companies, and he conceded the expenses of those proceedings at the conclusion of the case, and I think it was always agreed that he would have to pay the expenses of those proceedings. In that case, where you know up front he is going to be liable for those expenses, and on one view you can't really make an award of expenses for future expenses, rather than just having him find cation for expenses, you might in some case want him to simply make interim payment. There are other cases potentially where a trust, where there's, for example, disputes in succession of trust cases where it's said that if every part, in some of these, in the case of a disputed will, for example, it can be the case that every party will be entitled to the expenses out of the estate property in certain circumstances. And if you know that is going to be the case, then maybe for future expenses, you might be justified in making an award or making a motion for interim payment of expenses which you're almost certainly going to be found entitled to. Personally, I think you'd probably be quite brave to make that motion in Scotland before we've actually got to the point where it's accepted that we should regularly be making awards for interim payment of past expenses that or awards that have already been made. To I think, whilst I don't see any reason in principle to make an award for interim payment of expenses that have not been awarded, I'm not sure how well that would be received in the current, just quite at this time. But I think it's something in the future that could well be justified.
Okay, maybe someone will pay you for an opinion on that. I think that brings us to the end of these questions, and of course, counsel always being perfect in their assessments of time. We're almost bang on our hour, which is a good start, no doubt. People will be thrilled that your timing is so good in these things. I think that just takes us to the point where I get to say a thank you to Charles on behalf of all of today's attendees. Thank you, Charles. If any of the attendees have any comments or thoughts on the format of the seminar, please do let our clerks know. If you're lucky enough to have a ticket, the next Devil You Know seminar is next week with Andrew Crosby. For everyone else, look out for it on YouTube. Just leaves it for me to say thank you for joining us, and everyone have a good evening. Thank you.